Respected ma'am and my dear participants, a very good evening to all of you present here. I, Paras Chuk, a member of Legal Vidya, welcome you all on the second class of 45 Days Advanced Legal Drafting Certification course by Legal Vidya. So, without further ado, let's warmly welcome our esteemed speaker, Ms. Shivani Gupta ma'am, to the virtual stage. Welcome, ma'am.
Good evening, Legal Vidya. Good evening, participants present over here. Sorry, due to network glitch, I'm not able to connect with the mobile. That's why for a few minutes, I will join with the laptop and will share the screen. As soon as connect with the mobile, I will turn on the my camera also. Wait for a second. And today is the day 2 of the class, so we will start learning about the different stages of the criminal proceedings under the BNS, BSSA, etc. Wait for a second. I'm just sharing my screen. I'm just sharing the screen. My screen is visible to you all?
No, ma'am.
Okay, okay. I think it might be visible now.
Yes, ma'am.
Okay. Am I audible clearly?
Yes,
Trying to connect with the mobile, so could connect on the laptop also with the on the camera also with the same. Okay, thank you everyone. So we are starting. So today's session is about the criminal investigations. What are the different stages of the criminal investigations? What are the trials that are being introduced under the new criminal laws, that is BNSS, BNS, and BSA particularly. My dear students and everyone participating in the session, first of all, just keep one thing in your mind, that when we discuss about that what are the criminal investigations, what are the aspects of the drafting, that one thing we have to keep in mind, that is that before moving further jump into the aspect of drafting, that how the FIR is being drafted, how the bail is being drafted, we have to be acquainted with the certain aspects that newly legislated laws, criminal reformative laws, particularly BNS, BSA, and BNSS. So there are certain new laws, certain new procedures, certain new reforms being introduced. When we discuss about how the investigation will go on in the criminal proceedings at different stages in the different criminal courts that we studied yesterday section, so today in the continuation of that we will discuss that what how the investigation being conducted under the new laws, as we are acquainted with what's the process being followed under the old laws, naming as CRPC, IPC, and the Indian Evidence Act. The today's session I have particularly divided into two parts. Okay, because the regarding the criminal procedure, the investigation procedure is very wide aspect to discuss. The trial procedure, very wide topic to discuss. In the today's class in 1 hour, I will try to cover each and every aspect. Now, part one discusses about three particularly stages, three particular parts, that is investigations, stages of the evidences, stages of the bail. Part 2 particularly discuss about police report, next followed by the commitment of the case, and last we will discuss about particular session trials under the BNSS. I'm giving a pause to the slide. All of you, please for a second read the slide very carefully, because if you are acquainted with this slide, okay, two parts are there, and it makes easy to learn about the aspects of the investigation procedure under the criminal laws. Now comes the another aspect, that is we will start with the investigations, then will follow a part one. We are starting with the investigations. Now investigation is about what? Investigations means that how the provisions that are being enabling the advocates, the courts, just to further proceed, and what's the particularly look further before jumping into what's the investigation is, we have to be just acquainted with one thing, that why there is a need for the new criminal laws. Everyone knows that the new criminal laws are having the enhanced efficiency, that the criminal matters could be handled by the law enforcement and the judiciary by the uses of the technology, uses of the different artificial intelligence and such thing, and during the investigations, during the trials. So when we use the technology, when we use the different artificial intelligence aspects, then there are certain demonstrations of the statutory adaptations, but also it demonstrate about the advancement. So there are certain provisions that are acquainted, that are enabling the technology just to be made available for the investigation. That is the important aspect with the particular potential concerns. First part, that is the investigation. Now, investigation means what? Particularly a term everyone in the day-to-day life is acquainted with that term. This crime has been committed, or this thing has been happened. The act has been happened. The person is murdered. Now the police will investigate the case. Everyone is acquainted with this term. So investigation means particularly a term related to investigation means to commence, to start, means that particularly a act that is being categorized as a crime under the BNS, formerly known as the IPC in 1860, or any other penal statute I have mentioned, because you must not be like, okay, whatever the offenses that being made available in the IPC are only the offenses that are being punishable. No, there are certain other offenses that are also being made punishable, but as per the provisions of the IPC only, or in the collaboration with, we can say that. So investigation means to commence. To commence means what? The crime is being committed and that is being punishable. Now we are studying the new criminal law, so the crime must be punishable, the act must be punishable under the BNS 2023. Now comes there is another aspect also. Everyone is acquainted with the classification or classification. Classification is about what? The crime, nature of the crime. Either it's cognizable, either it's non-cognizable, either it's bailable, either it's non-bailable, either is compoundable, the nature, either it's non-compoundable, either cognizable crime or not. So the BNSS is particularly divided all the categories of the crimes in particularly a very other subject one by one chapters. Now what happened? The thing is that when you open the barrack of the BNSS, it's not humanly possible for me to share the first schedule of the BNSS here on the screen. So you can just keep the barrack with yourself, or you can be just like, okay, make your put in your mind that first schedule deals with the list or classification or the list of the offenses under the new criminal system, and the classification is already we are acquainted with. First classification comes with the category of the cognizable offenses. Cognizable offenses very easy and important, that non-bailable offenses, and non-bailable offenses is what? More serious in nature, or the cognizable offenses a police officer may, with the schedule or any other law, arrest without the warrant. So under cognizable offense, keep in mind two things: non-bailable, more serious nature, police officer can arrest without any warrant. Now there is I have mentioned one case law, also important case law, that is regarding the Lalita Kumari versus government of UP, where that already court held that police officer must mandatorily register FIR, and FIR if there are certain disclosing that any cognizable offenses was there or something like that. So that was a very contradictory thing that happened. And then now for this under section number 173, subsection number 3, That is the BNSS, sorry, clause 3, sorry. So the provision is given with the period of the 14 days. I have mentioned the case law because Lalita Kumari versus UP, government of UP, this case you have studied in the CRPC also, as were the section number 154 of the CRPC. That's the thing to keep in mind. Now comes our non-cognizable offenses. Non-cognizable offenses means that non-cognizable means not as such being severe, heinous in nature, and police officer having no authority without a warrant from the warrant that the magistrate will issue. The police officer will obtain that warrant or the order to arrest any person, and those provisions for the arrest any person are made under the section number 174 clause 2 of the BNSS. Okay, now if now the thing important to mention is this: if the offense is cognizable, then the police can treat or the police can arrest directly without the order of the magistrate. Now there is one another thing. But another thing is any of the police officer sometimes if refuses that he is not registering your FIR or he is not registering to the offense, then the person or the right party may approach the magistrate, and the application would be made under the section number 175 clause 3, that we directly approaching the magistrate. And earlier it was under the CRPC also, that cognizable offenses being committed, then what would happen, uh, the court will order that okay, the cognizable offense has been committed, so the investigation should be directly either made by any officer subordinate to him, or either directly by them only. Now there is a provision under section number 154 also, that if the provision is that any of the police officer can then register an FIR at their police station, and irrespective of the geographical status or irrespective of their area where the offense is being committed. So the police station will register the FIR to the concern, and they will deliver and they will transfer the FIR to the concerned police station under whose jurisdiction the offense being committed. So this provision of section number 154 is opposed now. Now comes very important aspect: investigation we are acquainted with regarding the cognizable offenses, non-cognizable offenses. Now comes stages of the offenses. This is a very important aspect when we discuss, because before directly jumping into what are the drafts, before directly jumping into how to write an FIR, how to write an bail application, how to make the evidences list, how to make the testamentary list, how to make the PW1 statement, PW2, DW1 and 2, and so on statement. One student must be acquainted with that. Okay, these are the stages of the evidences that are being counted under the criminal new criminal reforms. Once now what happened, I have already mentioned everything upon the slide. You easily can go through the slide, and read. Okay, though when we discuss about that FIR that is being registered, now comes the another aspect. Your FIR being registered, now what would happen? Evidence stage come, investigation is started. Now investigation is started means what? The FIR registered, the police will take the action, required action, and they will take the required action by what? First of all, they will collect all the evidences. Now the all the evidences are being collected. So police, the evidences stage are categorized into three particular stages. Number one is say a recording of the statement, and not to worry, I will discuss each and every aspect of each and every section in detail in the next 5 to 7 minutes. Before that, let you know that okay, these are the stages. So stages are particularly, first of all, under section number 180 of the BNSS, we will study that okay, recording the statements. The police officer will record the statement of the victim, accused, co-accused, and witnesses, and so on, the peoples, the right party, everyone. Okay, the statements are being recorded. Now comes another aspect, that is what? Collecting the evidence. Okay, the evidences are being collected, followed by what? There is any confession, any statement. So if there is any confession or the statement, need to be recorded before the magistrate specifically. Then what would happen? We will follow the provisions of section number 183. So we can say from 180 to 183, there is a stages of the evidences that are being counted. Now, as I already told you that I will explain each and every section and will try to mention sections language on the slide. So this is what a recording of the statements under section number 180. Recording of the statements is what? Recording of the statements is that if during the examination of the witnesses, the particularly first of all, so the investigation officer may issue the notice that okay, on the same particular date and the time you have to visit or attend the police station, and the purpose is that we have to record the statement of the witnesses, that the person who was the eyesightful witnesses who saw that what actually happened there, so we will record the statement. Okay, but the recorded statement is not admissible because it must be proved in the trial court by the adducing evidences. So this is also a thing to mention. I have already mentioned upon the side that this recorded statement is not admissible as a evidence and must be proved in the trial court by adducing the evidences. Now what would happen? Section number 180 on the clause 3 of the BNSS is particularly provide for the possibility statements being recorded by audio, video, electronic means. As I already told you, new criminal reforms are more about what? They are more about they are particularly more about usage of the technology. They are more about adaptive of the new tech, adaptive of the artificial intelligences, and so on. And legislation also followed that there must be mandatory language, and there must be the electronic usage, there must be the electronic thing for the examination of the witnesses, for the investigation to carry on. So this is what the section number 180 says. So now statements being recorded, now comes what? Now comes collecting the evidences. Collecting the evidences are like police officers, police officers of the police station are particularly empowered that they can collect the statement. For example, if regarding the collection of the statements, it requires uh, any of the blood remains on any of the soil, any of the cloth piece, any of the forensic evidences are also counted here. You might be just like, do it include the forensic evidences or not? So yes, forensic evidences, digital evidences is also there. If there are certain digital documents, any kind of electronic communication, either via WhatsApp, mail, or any other messaging services, any call recordings, or so these documentary evidences are relevant. And if the police officer thinks fit so that the documentary evidences are sufficient, and they could either summon any witness, they can summon any accused, and the provision for summoning the accused, summoning the witness is being given under section number 94. Now the statements are being recorded. Now the statements and the evidence is being collected, the accused, co-accused, witnesses are being summoned. Now happens what? Now it's important that you have called the accused, you have called the co-accused, you have called all the witness, victim, a bride party. Now there is a recording of section. Recording means what? Under the section number 183. This is a mistake in the heading, so I will correct in the slide. Actually, during the typing, it's a mistake. Recording of a statement under section number 183. This is the correct sentence. So you won't be like, okay, 183 sections recording a statement. What is this? So sorry for that. The heading is being wrong. So it's no need to worry. I will change in the PPT. Now it actually section number 183 says what? 183 is just like magistrate has to record the statement. Okay. Now magistrate will record the statement under section number 183. But it's just like there is a clause 6 also, that if there are certain offenses that are being committed in the particular sections, so those particular sections are about 64 to 124. It means all, not all the section. It's 64, 5, 6, 7, 8, 9, 70, 1, 2, 3, 4, 5, 3, 4, 5, 71, 4, 5, 6, 7, 8, 9, and 124 of the BNS. BNS means formerly known as the IPC. The statement will be recorded by the magistrate. And those, all the statements, it's very important. In the second point, I have already mentioned that under section number 183, if the statement is recorded, and it is then that recorded statement by the magistrate itself, and of the person against whom the offense is being committed, the admissible as the offenses is recorded before judicial officer under the oath, and that must be a admissible evidence. So for if the students, you are preparing for the judiciary examination, then you must be acquainted with this fact that the statements recorded under section number 183 are admissible as the evidences. Okay, now comes the another aspect, very interesting aspect. We will learn what the drafts of the bail, how the bail is being drafted. But in today I will share that okay, what are the stages, how could a person obtain the bail, how can the person be released on the bail. Any person named as an accused in the FIR can seek pre-arrest bail, that is anticipatory bail. Anticipatory bail can be granted either from the court of session or high court, or accused person also can be granted, or can sorry, not granted, but can look forward for the bail from the trial court, from the court of session court, or the high court. Regarding the bill, my dear participants, I will provide you, as the day passes, I will provide you each and every draft. Not to worry that in the drafting course we are not learning with the drafts. Before the drafts I shared with you each and every day, you must be acquainted with, okay, this is the provision dealing with the same aspects or same concept. And now regarding the bail, you have understood that there is a pre-arrest bail and there is a regular bail. Now, pre-arrest bail is also known as the anticipatory bail. Anticipatory bail means that there are certain conditions, or there are certain things that is high courts and the court of sessions are being empowered. Now, which section is empowering both the courts to grant the anticipatory bail? That is the section number 482. Now, section number 482 says what if they are court can also sometimes issue certain conditions, put forward certain conditions, or depending upon the case specific facts, that the person shall make himself available for interrogation every time or whenever required, and a condition that he will not tamper with the evidences, and whenever he will ask to cooperate in the investigation, he will be there. So there are certain conditions that are being put forward. But section number 482 deals about anticipatory bail under section number 482 of the BNSS. I will provide the draft of the BNSS anticipatory bail also. Okay. Oh, fine. Now comes another thing. The another thing is, is there any difference that, okay, in the CRPC also there were the provisions of the anticipatory bail. Now in the BNSS also the provisions of the anticipatory bail. So there will be thing in your mind that what's the difference between the both. So if anyone, if the screen is visible, you can already read on the screen that okay, there is a difference between both of them. Now the major difference is that legislation now, particularly the new legislation, it remove all the factors that are being consideration uh, taken into the consideration by the court for granting. So the factors that the court considered before granting the anticipatory bail was nature, gravity of the accusation, antecedents of the applicant, policy, possibility of fleeing from justice, and so on. So I think I already mentioned that this is a welcome step which will be appreciated by the court by deciding the applications for the anticipatory bail. The practicing advocates must be in the position like to understand, okay, so this aspect being removed, this factor being removed, and these considerations are being removed. So it's easy for the courts also just to grant the anticipatory bail. But they look, I have mentioned on the next slide what. However, it must be important to note, and yes, it's very important that anticipatory bail is not available for any of the heinous crimes or any of the heinous or unnatural crimes. For example, under section number 65, under section number 70, subsection number 2. For the rape of a minor, that is the child ages of below 16 years, or gang rape of the female, and that is the below age of 18 years respectively. So for those kind of offenses, there is no access provisions for the anticipatory bail. Now comes another aspect, interesting aspect, that is the regular bail. So regular bail means what? Regular bail means that you are just want to be free, and there must be the procedure that the court followed. The arrested person get or detained by any person that is being detained by the police officer without the warrant or produced, then in such conditions court can grant the bail before moving certain application. I will share the regular bail draft also from tomorrow. Now comes very important aspect, that is, we don't need to go in the detail of the same, but we have to be acquainted with, because when we discuss about the draft of the bail, so we must be acquainted with, okay, this provision stays with this or says this. Application for the regular bail can be moved by a person who has been arrested or detained. Arrested or detained word you can either use or not. You can't, don't use. It's all your choice. So without a warrant or any available office before any court other than the High Court or Court of Session. Now comes the bail under section number 483 of BNSS. It's what? The High Court and the Court of Session, yes, particularly have the power that who is in the custody on the certain conditions, that the court can free that person, court can grant the bail to that person. But the granted bail, the granted bail will be on certain conditions, and there must be like authorized person or any there must be the presence of any person or informant that who is also obligatory at the time of the hearing. And those provisions I will discuss detail, that drafts I will discuss in the share in the detail in the upcoming classes. But you have to for now keep in mind that under 483, and no high court shall grant to a person who is a tribal under section number 65, but the court can grant the bail on the certain conditions. Now another thing very important, and either I think advocates are very much struggling for that, the cancellation of the bail. The accused party is always like in the state of mind like the bail, oh sorry, the victim party must be like that, the bail must be cancelled or the bail must not be granted to the accused person. So if any of the court that is granting the bail under section number 40 can also cancel, and the cancel if the court is once granting the bail, they can also themselves cancel the bill. Why they can cancel the bill and how they can cancel the bill? So we on for that I will like to read a slide for you, because when we read the slide one word by word, you must be acquainted with, and there is no as such thing to explain or elaborate. Any of the court granting any bail under section number 1480 of the BNSS can cancel the bill. Already told you that has been granted and directed that the person in question be arrested and committed to custody. The same also done by the under section number 480 clause 5 of the BNSS. Now the High Court and the Court of Session can also cancel the bail that is being granted under section number 483 by invoking powers under section number 483 clause 3 of the BNS. And why it is worth mentioning, and why that despite there are several judgments on the cancellation, the legislature has chosen to remain silent on the ground that the which grounds the bail can be cancelled, because these are very unspecific grounds that the bail can be cancelled. If anyone are having any inputs for the same for the cancellation, I think the practicing advocates might have experienced these factors, so they can be just more expressively or comprehensively put throw light upon the fact, and I will take the note in the last, so keep in mind. So this also granting certain wide parts to the judiciary for cancelling the bail once granted. Now comes very important aspect, that is we are reaching to the another part, that is the police report. Now all the three stages of evidences are completed. As I already mentioned you upon the slide, all the three stages of the evidences are completed. So now the police must file. Actually, I'm unable to join the meeting from the mobile. That's why my camera is not working. From tomorrow, we'll try to just procure the technical glitch and we'll join by the camera. So kindly avoid today's class that no camera is there and you must be like, okay, I'm just audible, not visible. So please cooperate for today's session only. From tomorrow, I will try to be on the camera. After now,
Excuse me, one participant is saying, can you please speak a bit slow?
yeah, sure, we'll try to. Actually, there is a lot more to discuss with the law, and there is a very less time, a few minutes, just a 60 minutes class. So that's why we'll try to. And whatever I am discussing is already mentioned upon the slide, dear student. So now comes police report. Now, police report, we have come to the another aspect, that is, once all the three stages of the evidences are being completed, so the what the police will do now, and we are going for through the investigation only. The police must file their report under the section number 193 of the BNSS, and the report must be filed before the magistrate. And that is now, if the report is being submitted or the remote report is being filed before the magistrate, the investigation stage is being concluded, and the evidences are being collected, and what whoever the investigation and agency is there. Now, after the proper investigation, either done by the police officer, and finding all the evidences that are being working against the accused, and so they must be like, okay, the evidences that they have found are deficient, then they may file a report under section number 189 of the BNSS also. Now there is another provision also, that provision says so the accused may be released on the bond and with an undertaking to appear as and when required before the magistrate. So undertaking will be given, a bond will be signed by the accused, that okay, whenever the court asks him to appear, he will be there. Now, if the police, if we are talking about the police report, then there are two kinds of the police report particularly. First is a closure report, next is a charge sheet or the final report. Though we know the closure report or the FR or the charge sheet. Now we will discuss in detail about what is the closure report, what is the charge sheet, and the final report. Now, the closure report is what? Closure report is kind of a report that is being filed by the police officer. Now, once there is no as such evidences available, there are no as such facts available that proves that the alleged offense has been committed by particular accused person only, or we can't question the accused on the behalf of the aspects because there is no as such evidences being available. Then what would happen? Magistrate can do two things: either direct the investigation agency to just further investigate. This is a very common thing happened. Oh, okay, or either he wants to be like, okay, just accepted the report and close the case. So there are two facts facets always on a report that is being filed. Now, there is another thing, that is the charge sheet or the final report under the section number 193 of the BNS. Charge sheet means what? Charge sheet means that there is a particularly, I will share the format of the charge sheet, and the charge sheet format is available everywhere on the e-filing portals of the district courts. But I will share in detail and will explain you how the charge sheets are being filled, how the charges are being framed, and how the investigation taken up to the alleged accused or alleged acts are being introduced as the charges there. So charge sheet is particularly like, it also contain the complete investigation that police officer authorities have done, what are the charges they have labeled, and what are the briefing of the facts, briefing of the crime scene, yeah, and FIR copy, and statements that we recorded under section number 180, 183. There is another thing, that is who are the witnesses, that list being prepared, and what are the documents and documentary evidences they have uh, collected. So once the charge sheet is being filed, now what would happen? Now comes the another stage. Magistrate will issue any summons or a warrant to the accused and those named in the charge sheet, and direct him to appear before him on the date whatever the magistrate asks them to just whatever the magistrate ask them, that okay, you have to be there. Now, if the punishment another aspect is there, if the punishment offense is punishable less than 10 years, the final report under section number 193 of the BNSS shall be filed, and the time period is also given regarding the time, regarding the submission or filing of the report, and it's 60 days. Now, if the uh, if any of the offenses that is being punishable with imprisonment, or that is being punishable with the imprisonment more than 10 years, or death penalty, life imprisonment. So if that then in that condition, investigating agency have to file their reports with the date of 90 days. And these are being done for the speedy we can say delivery of the justices, and so on. So the time limit is being imposed now. It's not to just decrease the pendency of the cases. Now there is an important aspect, that is very important aspect, that is the session trial. Because for it's a drafting session, so we no need to go in the details of every aspect, but we have to be just like peripherally touch each and every aspect. And when we start learning about the drafts, then we must not be like, okay, we don't know what is bail, we don't know what is regular bail, anticipatory bail, we don't know what is the closure report. That's why I discussed each and every provision this way. Now comes the session trial. Session trial is what chapter number 19 of the process 19 of the BNSS deal with the same. That is the procedure of the session trials. How the trials must be conducted by the public prosecutors, or how the trials must be concluded, how the judgment must be there. So under section number 248 to section number 260 of the BNSS, the trial procedures are being discussed. Now, in rather than discussing the points of the sections, we will discuss, okay, the trial started this way, and these are the steps, so these are the drafts, because we have to focus mainly upon the drafts. Now what would happen once the trial being started? So trial being started means the police has filed the report. Now it's a court, some magistrate is a public prosecutor, it's accused, and the trial started. What would happen, how to start? So this is what that is section number 249. That is section number 249, opening the case. That is under section 249, prosecutor that are appointed, and that appointed prosecutor will explain all the charges labeled against the accused in the charge sheet to the court, because the charge sheet would be prepared by the already prepared by the police officer, investigating officer, or the investigating agency themselves. They prepare the charge sheet and they mark the charges as per the evidences available, they collected, they make the investigation, and so on. Now there are provisions for the discharge also, there are provisions for the framing of the charges also, under section number 250 and section number 251. We no need to go in detail that, okay, what are the provisions there, but we must be acquainted with, okay, if there are the opening of the case, if there are like explaining of the charges, so there are provisions for the discharging also, there are provisions for the framing of the charges also. And another thing, that is the plea bargain. Now the plea bargain principle, plea bargain application is reintroduced here also. Okay, so the plea bargain application having certain requirements, for example, offense punishment must not exceed 7 years, offense must not be affect the social economic condition, or offense must not be committed against any child or the women. So application can be filed by the accused itself. And the for the that plea bargain, the section is section number 290 of the BNSS. That is that the making the accused to file an application under section number 290. Now, if there is a conviction of plea of guilty, then what would happen? Then at this stage, no such draft is required. But if the accused doesn't plead guilty, then the court or the judge will shall directly order trial to proceed. And now comes the important aspect, that is the prosecution's evidence. Prosecution evidence play a very crucial role, because prosecution evidence is what it is a stage that is comprising of the examination of the witnesses, either examination of the witnesses from the accused side, or the examination of the witnesses from the aggrieved party, victim side. So the examination of the witnesses include what that it is also includes the chief examination, cross examination, and the re-examination. There are certain possibilities that we have enhanced the new laws with the technology. So BNSS also provided the possibility of the recording of the deposition of the evidences through audio video electronic means. And this audio video electronic means evidence collection disposition deposition was not there as such in the CRPC. So we that's why I have mentioned this slide as a heading with the prosecution evidences, section number 253 and the 254. Accused may and the judge direct the accused to appear in the witness box and repeat and record the statement. That is section number 351. We no need to go in the detail. Now comes another aspect that okay, the practicing advocates and the students must be acquainted with that under section number 351 the recording of the statements are there. Now what would happen? The judges can allow, sometimes allow, or can allow through their counsels, through their advocates to produce any defense witnesses, and if are then their witnesses, so called witnesses, will be examined, cross-examined, chief examined, re-examined. Okay, now comes a last not the least aspect, that is the final argument. Final argument will be made, and a final argument will be made that after proper evaluation of the statements, testimony of the witnesses, and there are all oral arguments also, there are evidences also, there are testimony of witnesses also. Then what would happen? And then the verdict, quantum of punishment, or the judgment will be awarded, and the judgment will be detailed judgment. Then recording all the statements, reasons will be there. Now these are all the we can say these are all the stages of the criminal trial that are being from the investigation to the verdict. And that's all for the today's presentation. But now I will like to take one by one each of one of your query regarding the same. Ma'am, can you speak a little bit? Now I will check the messages one by one. And for the conclusion, I think there is no need to read loudly the conclusion because we already know that there is a very huge procedure and the time taking procedure. There are certain and lower courts are improving their infra, so there is a time that will be there to achieve the administrative efficiency. And I have put the slide of conclusion, so you can read it by yourself also. Now we'll take the queries one by one, and it's an open discussion platform, so please can you unmute, and if you wish to, then put in the chat box. Voice is breaking. Statement. Biradar Akash Azmi. So, madam, if a statement made only before the police, then non-admissible. Regarding what you are saying, only before the police, non-admissible. No, it's not like that. It's not admissible every time. It depends upon the circumstances also. And if it is admissible only if it is made with the another evidences to prove, okay, this evidence is supported by these other factors, then only it will be admissible, Brother Akash. Recorded session will be provided. And yes, in every case, the bail for Vani asks, in every case, the bail format is same or different. Look, Vani, the format that is being prescribed under the schedule of the BNSS, the format is same, but the content that is being you are asking for on the grounds, they can be varied. But the format is same, the content is different. The students are every time confused about that. Kindly share the format, or kindly share. Okay, the format, the writing is style, the presentation of the facts is same, but this is what your requirements is for what, or what the offenses your accused has been committed, or what are the things you are being asking the bail upon. So the content inside that must be different. For example, you are writing a formal letter, so the format for writing a formal letter is always just starting with to whom you are addressing, followed by your address and subject and so on. In the same way, the format is same and the content is different. Labib, can you speak a bit slow? Anmol Kashyap. Police report is also called the charge sheet. No, police report is never called as the charge sheet. Look, what are the kind of a police report? The police is submitting the report before the magistrate. Then, if the police is submitting the report containing the charges against the accused, then this is known as the charge sheet. If police is submitting a report or filing a report before the magistrate and it doesn't contain any charges, or it is stating that there are no as such sufficient evidences available, then it is the closure report. Okay. Anmol Kashyap once again asked, can victim person see the charge sheet? Yes, victim person can sometimes see the charge sheet and the charges that are being put forward, that are the accused being charged is announced in the court. Also, public prosecutor will announce that, okay, these are the charges. Saurav Kumar, can you explain about the section number 488 of the BNSS? For now time being, there is no such requirement to take the sections as per thoroughly. Would you provide the PPT in the group? Yes, PPT will be provided. If PPT shared, that would be given in yesterday. Okay, Hanif, I will share the PPT to the legal Vidya. Okay, PPT. I will share the PPT. It's not a big deal. Labib, is the speed justice practically applicable in the Indian district court? Labib Agha. Kindly please refer to the conclusion slide, because this is a conclusion I actually made upon a certain aspects, because my research is going upon the same. I have already mentioned in the last few slides that there is a time taking thing. Time taking thing, why? Because the lower courts are not well, lower courts are just not, administrative efficiency is not there, tech tech is not there. So there is that thing that there is a overwhelming backlogs of the matter. So it will take a on-table timeline. Okay. Now, and yes, speedy justice will be practically applicable in the distinct courts. Be optimistic. Now, another question. Sorry, I lost the questions. Madam, can you please share the formats beforehand? Yes, I will provide the format, Gemini Patel, once I start explaining the same. But before that, you have to be must acquainted with the terms and so on. Uh, Anmol Kashyap once again asked, and its procedure. There is no such procedure being made that the victim can see the charge sheet. The prosecutor will announce it. And there is no such procedure. You can ask the court officer to just show you the documents. Arpit Gupta. Can a person take anticipatory bail in the cognizable offences? No, at such cognizable offences, anticipatory bail is not provided. Anticipatory bail is and particularly as such, no as such thing is mentioned that the anticipatory bail will be provided in these cases or not. These cases, the offences against the women and the children, the anticipatory bail will not be provided. Offences against the state, anticipatory bail will not be provided. There are certain conditions that the anticipatory bail will be provided, and depends upon the circumstances. One is the police report and the charge sheet is false, just to trouble the victim. How to come out of that? It's a clear corruption, and it's a case of a corruption, Vani. If the report and the charge sheet is false, if the offense is being committed, the crime is committed, then how the charge sheet can be false? It's not practically possible. If the evidences are there, then you can directly approach the court also. If the police do so. Okay. Now, is there any other question? Please, Anmol. Okay. Any other question? Any other thing you want to know? You want to just ask me, Madam? Arpit, Madam, what about the hit and run case? Can he take the anticipatory bail? Actually, if there is a that hit and run that caused, or the person being detained at the place. And the person is being detained at the place, then there are no as such provisions for the anticipatory bail, because a hit and run case will be considered under the cognizable offense. Saurav Kumar, can you suggest any YouTube channel for the lecture of BNSS? YouTube channel for now, I don't think so. Is there any lecture? Sony, if crime committed is bailable, what charges? But charges of frames are non-bailable. What are the remedies? First of all, Sony, if crime is committed bailable, then how the police officer? Okay, it can be a human error that the charges named are non-bailable. It can be human error, and it can be resolved on the place. But and you have mentioned a term, what are remedies? Sony, remedies are no, remedies are kind of a reliefs that are being granted to the damage or the injury. It's not a damage or the injury. It is just like a thing that is a human error, and that human error can be processed, can be improvised, can be changed. Okay, Sony. Now, anyone other have any question? Then please put in the chat box, and then we will end the session. If the okay, okay, Sony. Any further question? Unmute yourself or either put in the chat box. No one have any question? Don't be shy and to ask the question, because in law, as much as you discuss, uh, then only you will learn a lot. And regarding that, today we have discussed the aspect that today we have discussed that what are the criminal stages. Now we comes to the theory part is being most of the theory part is being covered in the 2 days. Now the things that I have discussed today, a lot more things I have discussed today regarding FIR. Okay, NCR I have not discussed. The non-cognizable report I have not discussed, but that is also being taught in the class of in the criminal reforms or the criminal laws. Bail, and from tomorrow we will start discussing. And Mohammed. Yeah, Sayyad. Okay. From tomorrow, I will start explaining you what are the drafts. Can accused be asked for the written statement signed by him in the police station? Accused be asked for written statement? I didn't get your question. If you are asking that the police officer and the called any accused, oh sorry, detained any accused, or then the statement would be recorded and that must be signed and the countersigned by the police officer. It's a due course process. It's a documentary process that must be followed. But in what way you are asking? Couldn't get you. Accused be asked for written statement. Written statement from what side? Yes, the statement would be recorded. Labib Aga, what is remand? Actually, there is no such provision in the new criminal laws being for the remand. Remand is a kind of a thing that is the police took the accused in custody just to collect the evidences to record the statement of the accused. That is. Arpit Gupta, recently the Gurugram car driver hit a bike rider, but he got the anticipatory bill. How before the car driver look, Arpit Gupta, if you belong to a law fraternity, then you can't be just like on a piece of a newspaper news or on the piece of a news that are being live streaming. You can't decide that, okay, these are the facts, and on these facts, the court announces the judgments. The court, whenever announce the judgment, then they examine each and every fact in very deeply, and there are certain hidden factors, there are certain factors that are being not in the public domain on which the judgment is being announced. So you can't question that how it happened. If it happened, then there are certain grounds to support that provision. Okay, Saurabh Kumar, 37 of the under section number 37 for the grant is satisfied that there are reasonable grounds that for not believing that he is not guilty of such offense and such a okay, good question, Saurabh Kumar, but reasonable grounds are not being mentioned anywhere. Legislation has also keep themselves silent. So these are the loopholes, na? So you can say that there are certain scopes of the improvisation in the new laws. No certain reasonable grounds are there. It's depend upon the circumstances. How we will understand? Look, Saurabh, it's about the circumstances. Reasonable grounds, because once the core legislation prescribe the reasonable grounds, then they will be like putting the limitations. So also just not putting the limitations, those grounds are not being explained. I hope you got it. A Sony. If a bail application is denied, can the accused reapply anywhere else? I didn't get your hierarchy of reapplications. Yeah, if a bail is denied, then oh yeah, you can anywhere else. How could you file the application anywhere else, not anywhere else in the same court? So many times police officer get the signature of the same which are framed by them and just to complete the process. This is not the thing to discuss in the class that the police what the police officers are doing, but there is no such provisions. But the statement being recorded is signed by the accused and the counter signed by the police officer. And if any of the police officer is doing so, if doing any framing their statement on this statement and doing so, then you must report it to the senior officer or the superintendent of the police for the same, because it's a case of a corruption and the malicious practices. I think that's all enough for today's session. I think I have tried to clear most of your doubts. And if anyone else, then please just put fast in the chat box. Yes, and more. Thank you. Yes, anyone has raised the hand. Okay, okay. Thank you. Arpit, thank you. Yes, okay. Thank you, everyone. Devashi, Sardar, Vani, and Vijay. Thank you. I think today some of the doubts are cleared. I'm able to clear your doubts, and from tomorrow we'll try to just turn on the camera. And thank you for joining the session. Thank you, Legal Vidya. Happy learning. Please share the presentation today and tomorrow. Yes, I'm sharing to the Legal Vidya, and they will post it you. Okay, I will. I will share to them. Not to worry for the deputies. Okay, thank you. And yes, over to you, Legal Vidya. If you have something to share, then
Thank you, ma'am. As we
thanks.
come to the end of our second session of the Advanced Legal Drafting Certification course, thank you so much, ma'am, to take a wonderful session and explain the hierarchy of codes and the criminal codes, BSA, BNSS, and BNSS. And who thanks to all the participants who have stayed in the class. And lastly, to all of you, let's continue this momentum. I hope you found today's class as enlightening as I did, and I'm sure we are all looking forward to the upcoming sessions where we will dive even deeper into the intricacies of civil and criminal drafting, and we will share our one feedback form in the group itself. Kindly fill that. If you want any other changes in your classes, please let us know. And thank you once again, and see you all in the next class. Thank you, everyone. Now you can leave the meeting.
Thank you and good night. Happy learning.